We learned this week that the chief judge in the Southern District of Florida, who's essentially Judge Cannon's boss, had went to Judge Cannon along with another federal judge when the Trump Mar-a-Lago case was assigned to Judge Cannon to tell Judge Cannon she really shouldn't be taking the case, that it would be a bad look for the federal judiciary and specifically the Southern District of Florida, and that she needs to recuse herself, but Judge Cannon refused. The very fact that the chief judge of the Southern District of Florida made this request and Judge Cannon rejected it is unprecedented. And the very fact that something like this would even leak to the press is something unprecedented. It shows you just how unhappy and how embarrassed, how humiliated the Southern District of Florida judges are by Judge Eileen Cannon's behavior. And she continued to embarrass them this week. She held a bizarre hearing, and I think this is one of the reasons why it leaked the day it did. She held a bizarre hearing to listen to Donald Trump's motion to dismiss the indictment on the grounds that the special counsel was unlawfully appointed. And then next week, she's going to be hearing oral argument that the appropriations, the money spent for the special counsel, is also illegal, and therefore the entire case should be dismissed. This goes against decades of precedent. There shouldn't even be a motion on this, yet alone a hearing where Judge Cannon invited amici, third parties who submitted amicus briefs, to just show up and argue as if they are parties when they are not parties to the action. But she acted fairly normal in the hearing, and she didn't seem inclined to grant the motion to dismiss. But it's just odd that she was holding this hearing in the first place and kind of wasting everybody's time. So we'll get into that. And then last night, Special Counsel Jack Smith filed his reply brief regarding the modification of Trump's terms of release to put a gag order on Donald Trump, criminal defendant, convicted felon, from further lying that he is actively being the target of assassination attempts by the FBI and the Department of Justice, which is patently false. Jack Smith uses very terse and powerful language in this reply saying no court at all would allow a criminal defendant to engage in this behavior. So we are asking for you to do what any other court would do in this situation. Jack Smith also mentioned another incident last week where an FBI agent had his life threatened as a result of Donald Trump's conduct. So a lot to unpack there. Then we'll unpack what went down at the Supreme Court this week and also what didn't go down. The Supreme Court did not make any rulings on the issue of Trump's claim that he can order SEAL Team 6 to kill his political enemies and receive absolute immunity, nor did the Supreme Court rule on the obstruction of official proceeding challenges or claims that have been challenged, which are two of the charges against Donald Trump and charges that resulted in a lot of convictions against some of the most violent insurrectionists. The Supreme Court did rule on a case called U.S. versus Rahimi, which is a case involving regulations regarding domestic violence restraining orders and whether domestic abusers could are required to give up their weapons or if they can continue to have their weapons. We will go over the ruling in that case. And then we should turn our attention to what was going on in the New York criminal proceedings against Donald Trump in Manhattan. There you have the highest court in New York, which is called the Court of Appeals, rejects Donald Trump's appeal of the gag order and states that, get out of here. There's no substantial constitutional questions at all for us to even listen to this. It's dismissed sua sponte without even briefing. This isn't an issue that even deserves our attention, is what New York's highest court said. And then you had the the Manhattan District Attorney's Office. They filed their opposition to Trump's request to lift the gag order. Trump saying that he needs to lift the gag order because of the debate and that the trial is no longer taking place. the Manhattan District Attorney's Office says we need to respect the integrity of these proceedings. The political aspects have nothing to do with a criminal case at all. And the briefing schedule that is currently at issue was never even objected to by Donald Trump in the first place. So if Trump is trying to claim that the judge and the district attorneys rigged the briefing schedule by scheduling a briefing on the issue of lifting the gag order so that it's heard after the debate, as the district attorney said, that's none of our business to begin with. But Donald Trump didn't object to the current briefing schedule, which is the same briefing schedule for all motions. So, Michael Popak, a lot to discuss on this week. It's still a pretty busy week. And, we didn't get those Supreme Court decisions. We'll talk about just the impact of the fact that they haven't even ruled yet. But let's get into it. Huh? How are you?
I'm doing great. I want to take a special shout out, two thank yous. One to the Patreon community. We just did our first quarterly Zoom, you and me, Q&A. We had sort of a last minute announcement. We had over 200 people that participated, and it was very heartwarming and very great, touching for us, and to see the community, all those happy, shiny faces in one place. And we opened it up to all membership levels just for that. So I really appreciate people jumping on that relatively early in the morning. And then the outpouring of support and love and affection for my wife and me about our upcoming child I also wanted to make a special note about that, and just feeling the love from this amazing Midas Touch and Legal AF community. And then we got to do all that in sharp contrast to what's going on outside my window, which is a Supreme Court that's holding America hostage, day number 115, since they should have ruled, since the oral argument on the immunity decision, which is the decision we're all waiting on. Yeah, they keep rolling out drips and drabs, and they're kind of staging, the Supreme Court is staging how they're sending out their orders. Let's do all the ones that show bipartisanship, that show 9-0 and 7-2 and a couple of 6-3s, while we're all waiting around for the thing that should have happened back in December or January, with that trial already in the books against Donald Trump. And instead, they're still issuing rulings. They're important ones. We're going to talk about the gun control and their sort of attempted mulligan do-over of Clarence Thomas's Supreme Court decision just 2 years ago in the Berlin decision. And they're kind of like, we might have made a mistake on how we've been directing or misdirecting the trial court level. To which Ketanji Brown Jackson said, yeah, it's our fault. And we need to kind of fix what Clarence Thomas wrought. And so we'll talk about all that. And the Canon hearing, which you and I will go at length about during this particular podcast, and is not done. 2 more days next week. I mean, anytime Canon with her toolbox goes under the hood of this case is a white knuckle moment for America. And we'll talk about what we've learned about that last hearing, about whether Jack Smith should be Jack Smith at all, whether there should be a special counsel or prosecutor, whether the whole prosecution should just go up in flames and smoke and be dismissed because, despite 50-year-old precedent of the United States Supreme Court involving a former, the last criminal president named Richard Nixon, this hasn't gotten through the thick-headedness of Judge Canon. And we see it time and time again in how she grills and presses the Department of Justice about things that is basically settled law and received wisdom in this area of constitutional practice and the appointment of a special prosecutor, special counsel, independent counsel, whatever you may call it. And then we're going to see what happens when she goes back into this case in the next 2 weeks. In the meantime, other current judges that she works with, including her bosses, as you pointed out, judges from around the country, are all pointing out, you haven't even set the trial yet. How is that possible? And what does that say about your true intent here, which is to benefit Donald Trump? Just as the United States Supreme Court refusing to issue the decision until what looks to be the last day when they go wheels up on their private jets, paid for by Federalist and Maga on their, junkets overseas. They're not going to issue that immunity decision until it is impossible for the DC election interference case in whatever shape or form to get off the ground and be tried before the November election.
Michael Popak, you practice both in New York and Florida. You've practiced in state court and federal courts in Florida, in the Southern District of Florida as well. So you know the players in this story. You know who the chief judge is, Cecilia Altonaga. And this New York Times bombshell report, something that is very unprecedented. One, that a story like this even leaks to begin with. Usually this is all done in secret, and where you have two federal judges, more senior judges, counseling a junior judge, Judge Canon, a new judge, and especially a new judge at the time they counseled her as well. That never leaks because it's usually only the judges who could be the source of a story like that, and they don't usually tell other people. That's why it's so rare that it leaks. But the Times got the scoop that the chief judge, Cecilia Altonaga, who you've mentioned before, and you've said before this story, for those legal AFers who have been listening for quite some time, you said, look, Ben, legal AFers, I know that chief judge. Yes, she was appointed by George W. Bush. This, though, is a no-nonsense law and order judge who is a great judge. She's a real mainstream conservative, not a MAGA, and she will not be happy with the way Judge Canon is behaving. And sure enough, we now learned, and Popak, you called it, man, that Judge Altonaga, Chief Judge Altonaga, along with another more senior to Judge Canon, federal judge, they all work in the same.
And I have an idea, Ben, who that is when it turns to me.
I'm going to turn it to you right now. They went to Canon and said, you can't be on this case. You were appointed by Donald Trump, number one. Number two, you mishandled the search warrant that was executed at Mar-a-Lago and embarrassed this district when the 11th Circuit smacked you down twice in two scathing orders. This is a bad look for everyone. And three, you don't have in Fort Pierce sensitive compartmented information facilities to even hear classified document cases. You're going to force taxpayers to build a facility in Fort Pierce where we have judges who have done trials before, unlike you, who has no trial experience, Judge Canon. We have skiffs in Miami, and we'll have law and order judges handle it. Step aside, Judge Canon said no. How strange, how rare is this, how unprecedented? Popak, you know these people involved. Tell us about it.
I do, and I appreciate that. I tried to bring, just as you do from your practice, my own color, no pun intended with my colors today, including my glasses, my own color from having practiced down there. I know Cecilia Altonaga very, very well because she started on the circuit court, the state level court, where a lot of judges at the federal Southern District of Florida level start, most of them in Miami, some of them in West Palm Beach and Fort Lauderdale, but most of them in Miami. She was appointed by Jeb Bush when he was the governor and elevated to the position from the civil court to the circuit court. And I practiced in front of her. She is the first female Cuban-American woman to be a federal judge, takes that with a tremendous amount of pride. Her appointment by George W. Bush tells you everything that you just summarized that you need to know about Cecilia Altonaga. She is not a ideologue. She is not MAGA. She predates MAGA. She's 61 years old. She went to Yale Law School. She started her career as her father came here as a lawyer who couldn't practice from Cuba. And she takes her position very, very seriously. And I said early on that there would be a phone call between Cecilia Altonaga and Judge Canon, although she couldn't replace her. She couldn't remove her with some sage advice. I anticipated that, knowing Cecilia Altonaga, and it looks like that's true. On the case of the second judge, if I had to make a prediction, I'll do it here. I think it's Judge Middlebrooks. Judge Middlebrooks is the senior judge in that same division. He sits in West Palm Beach. She sits 30 miles north in Fort Pierce. It could be another judge in Fort Lauderdale. There's a few there. There's a bunch in Miami. But if I had a gun to my head, I would say Don Middlebrooks, who's also the judge people know, who's been involved with the Hillary Clinton case brought by Donald Trump, the sanctions for over $1 million brought against Donald Trump and Alina Habba. But he is also a no-nonsense. Yes, he was appointed by Clinton, but so what? He was a very well-respected trial lawyer for about 20 years, doing what you and I do, commercial litigation, civil rights litigation in that area. I know the firm he was with. I had one of my first cases as a young lawyer when I was second chairing a federal case in West Palm Beach with Don Middlebrooks. Always found him to be, ever since, just an astute, sober jurist, which is all that we've ever seen. I think because they rub elbows a little bit. She sits occasionally in West Palm Beach. And it could have went to Don Middlebrooks, but there was I forget the reason, that the wheel, when it fell on her and not on Don Middlebrooks. Now, you're exactly right. This cadre of more senior, seasoned litigators, trial lawyers, who I've said all had litigation experience and would be really, really appropriate and do great honor to the proud tradition of the Southern District of Florida, unlike what's going on right now, which is making my heart hurt and my brain hurt in watching this judge who is so inexperienced and so it's a dangerous combination. It is this lack of knowledge and experience combined with the self-righteousness that she is doing the right thing and only she can make these decisions the way she's making them. She had no trial experience to speak of when she was an associate in a private law firm. I'm talking about Judge Canon now. She had no real trial experience when she worked for the Department of Justice, because she didn't even work in the trial division. She worked in the appeal division, meaning she sat in some room writing briefs, and I doubt she argued them. And if she did, they were on very low-level issues. She then took the bench effectively during COVID. She had about 10 total trial days under her belt, total, before she got assigned this case. And Altonaga said to her, it's a bad look. Think of the optics. You got slapped back twice by our bosses at the 11th Circuit before this case even led to an indictment, when you interfered inappropriately with the investigation, which you shouldn't have, not once, but twice. It's a bad look. Elaine, why don't you think about stepping down? Words to that effect. And then, as you said, they don't even have the hardened facility that's necessary in Fort Pierce, because it's this backwater division up in the upper regions of the Southern District, about as far away from Miami and Key West as possible, which is the entire district. And so she forced, as you said, taxpayer dollars to be used out of her ego to build a facility it's like a disposable facility. It'll never be used again. There's never going to be a Classified Information Procedures Act SIPA case involving a former president or anything like it in Fort Pierce, Florida. They might as well just make it the Aileen Cannon Memorial Museum, because when she either leaves the bench and goes and takes a lucrative Maga private practice position for millions of dollars, or it somehow gets elevated by a, shudder to think, President Donald Trump, which is what she seems to be trying out for. And then you had the hearing. And I'll just do my part of the hearing, turn it back to you. She has the hearing where, for me, there's a lot of things going on between what happened on Thursday, Friday, and what's going to happen Monday, Tuesday. That scares the living crap out of me. As I said, whenever she goes under the hood of this case, I get really, really upset and crazed. So I'm just trying to hold it together here for legal AF. Next week, she's going to decide whether suppression of the evidence related to Mar-a-Lago and the execution of the search warrant, which is the very heart of the case. The case is about the evidence that was seized during the search warrant. If she suppresses it, the case is over. Yes, it's an appellate grounds, and it's a way to get to the 11th Circuit. I'll leave that to you. But that scares the crap out of me. The fact that she would try to reconsider the well-thought-out decision by the then Chief Judge of the D.C. Circuit Court, Beryl Howell, who, after a secret hearing, yes, they're secret hearings because they involve grand jury proceedings, she determined that Donald Trump and his then main lawyer for Mar-a-Lago, Evan Corcoran, committed a crime or a fraud, stripping Donald Trump of the attorney-client privilege and making him testify, Evan Corcoran, damningly against his client, and turn over 50 pages of single-space notes, and turn over video memo recordings that he made, musings about Donald Trump, in which he basically told him that he should break the law. And that Donald Trump, which demonstrates the willful intent, that is the corrupt intent that's required to turn this into a crime. Without Evan Corcoran's testimony, without the documents at Mar-a-Lago, this case can't be won by the special counsel. And in addition to that, we've got a Aileen Cannon that either fell asleep at law school or refuses to acknowledge well-settled super precedent that going back to Nixon from 1974 that says whether you call it the special prosecutor appointed by the Department of Justice and acting Attorney General Robert Bork back in 1974 of Leon Jaworski to go after Nixon and everybody around him, which led to the indictments and convictions and jail time for people like the Attorney General under Richard Nixon. Whether you call it the special prosecutor, who was not appointed or confirmed by Congress, but was implicitly and tacitly approved by the Supreme Court, who forced Richard Nixon over his executive privilege assertion, sound familiar, to turn over his recorded tapes to the special prosecutor. If the special prosecutor was invalid, then how would the Supreme Court order that there be compliance with his subpoena? That's 1974. It's almost to a day. It's July 7th of 1974 or so when that decision came out. So you got that. And then you had the independent counsel position, which was created by Congress, yes, in the 1980s, and there was an exact a checklist of things about the creation of an office called the independent counsel, and that's Ken Starr and a couple of others that happened during that particular time. And then the Congress, both Republican and Democrat, said, well, no, we don't like the independent counsel. Let's let the Department of Justice do their own thing. And they didn't reauthorize the independent counsel. So the Department of Justice went back to what it did during Nixon and created a formalized special counsel. It's just like the special prosecutor, but they gave it another name, and they outlined it in their Code of Federal Regulation of exactly how they wanted the person to be appointed and the oversight that the Attorney General would have over that position, and the checks and balance of the Attorney General having to report ultimately to the ranking committee members of the House and Senate Judiciary Committee about the report and the recommendation whether to seek an indictment and continue to prosecute the case, ultimately in the hands of the Attorney General. But to Aileen Cannon, who took the bait again, led by Emile Beauvais, fresh off his 34-count conviction of his client in New York, she said, it's very interesting. Tell me more about let me grill the Department of Justice lawyer, James Pierce. Let me ask him more questions. Tell me exactly the level of oversight and supervision by Merrick Garland. Go read the the special counsel provision. That will tell you the level of supervision. And it is appropriate as she's trying to decide whether there's been an improper delegation by the Department of Justice Attorney General for the last 35 years. Every federal judge that has faced this issue and had this issue raised for them quickly dispatched it and said, this is Boulderdash. And this is, let's move on to the substance of the case. Not Aileen Cannon, so interested that she spent 5 hours, including having, as you said, the amicus briefers, 2 of which are pro-Trumpers, get up and do argument. Look, we're in an adversarial process. We rely on the lawyers for the case, the party's lawyers, Trump's lawyers, and the Department of Justice lawyers. We don't have outsider strangers drive by who just happen to check the board and see that there's a trial going on or a hearing going on and saying, can we come in and make an argument? I'd love to do that. I would just ride the circuit making arguments in cases I have no business or standing in participating in. This is the world of Aileen Cannon. Now you understand why some combination of Chief Judge Altonaga and maybe Don Middlebrooks told her, get the F out of this case. And she refused. And I want to hear your opinion about why she refused to get out of the case when she had the opportunity, without us knowing about it, to recuse herself.
Because she's a MAGA judge and she's taken the gamble that she wants to be a Supreme Court justice. She knows she doesn't have the skills, qualifications, and like lots of MAGA, she can't do it on the merit because she doesn't have the intellectual capacity, but she does have the capacity for corruption and the desire and ability to utilize anything it takes to try to get that power. And that's what we see. I want to talk a little bit more about that hearing. I want to talk about what special counsel Jack Smith filed. Then I want to turn to what went down in the Supreme Court. And then we'll talk about what went down in New York's highest court. Let's take our first quick break of the show.
These days, a lot of people are learning about all the benefits of fasting, like weight loss, mental and physical performance, and gut health, but worry about the whole not eating part. Well, that's exactly why Prolon was created. Introducing Prolon, a revolutionary plant-based nutrition program that nourishes the body while making cells believe they're fasting. Researched and developed for decades at the University of Southern California Longevity Institute and backed by leading U.S. medical centers, Prolon helps promote healthy blood sugar, support cardiovascular health, and reduce abdominal fat. But Prolon isn't a diet. Prolon is science. Science based on Nobel Prize-winning discoveries in medicine. And this all starts with Prolon's 5-day program. Snacks, soups, and beverages, all designed to keep your body in a fasting state. It's unlike anything you've ever experienced. Prolon has nutrition plans down to a science. It's convenient, backed by Nobel-winning science, and it works. Being able to tackle my blood sugar levels and cardiovascular health within the same plan is a game changer. I've already been able to feel the Prolon difference after just 1 week. It's no wonder why thousands of doctors now recommend Prolon to support healthy blood sugar and cardiovascular health. Right now, Prolon is offering Legal AF by Midas Touch listeners 15% off their 5-day nutrition program. Go to prolonlife.com/legalaf. That's prolonlife.com/legalaf for this special offer. That's prolon.com/legalaf. It's hot outside, and your nighttime bedroom temperature has a huge impact on your sleep quality. If you wake up too hot or too cold, I highly recommend you check out Miracle Made's bed sheets. Using silver-infused fabrics inspired by NASA, Miracle Made sheets are thermoregulating and designed to keep you at the perfect temperature all night long, no matter the weather. So you get better sleep every night. These sheets are infused with silver that prevent up to 99.7% of bacterial growth, leaving them to stay cleaner and fresh 3 times longer than other sheets. No more gross odors. Miracle sheets are luxuriously comfortable without the high price tag of other luxury brands, and feel as nice, if not nicer, than sheets used by some 5-star hotels. Stop sleeping on bacteria. Bacteria can clog your pores, causing breakouts and acne. Sleep clean with Miracle. Go to trymiracle.com/legalaf to try Miracle Made sheets today. And whether you're buying them for yourself or as a gift for a loved one, if you order today, you can save over 40%. And if you use our promo code LegalAF at checkout, you'll get 3 free towels and save an extra 20%. Miracle is so confident in their product, it's backed with a 30-day money-back guarantee. So if you aren't 100% satisfied, you'll get a full refund. Upgrade your sleep with Miracle Made. Go to trymiracle.com/legalaf and use the code LegalAF to claim your free 3-piece towel set and save over 40% off. Again, that's trymiracle.com/legalaf to treat yourself. Thank you, Miracle Made, for sponsoring this episode.
Michael Popak, some great ad reads right there. Thanks to our sponsors. In the description below, you get those discount codes, and we use all of the products that we have as our sponsors here. Jordy spends a great deal of time vetting it, and so we're really grateful for them. That's one of the ways we build our independent media platform and grow the show. Another way is through Patreon, patreon.com/legalaf. And Michael Popak, as you mentioned in the beginning of the show, we just held our first partner and associate meeting on Zoom. We had over 200 people who were in that Zoom. We got to meet everybody. We answered pretty much every single question, some tough questions, some fun questions. We had a great time meeting you. I know there's been so many people who wanted to meet Michael Popak directly, and they got a chance at the Zoom meeting, patreon.com/legalaf. Briefly, Michael Popak, I'll mention that hearing that took place in Judge Cannon's courtroom that you discussed, Donald Trump's motion to dismiss the indictment on the unlawful appointment, unlawful appropriations. You laid out essentially what the challenge challenges that has been rejected over several decades, trying to say a special counsel or an independent counsel is actually a superior officer. As a result, they need Senate confirmation. With no Senate confirmation, they are acting in an ultra vires, illegal manner, and anything they touch is unlawful. They are technically supervised. They are inferior officers. They are supervised by the Attorney General. They have to comply with the Attorney General guidelines. The supervision's not micromanagement, but one of the things that Judge Canon really seemed to want to do and why she was holding this hearing was to try to fuel and funnel some of these right-wing conspiracies about the level of supervision of Merrick Garland to an inferior officer, the special counsel, because the argument would go, if the special counsel has nothing to do with the Attorney General, they're functioning as a superior officer, and as a result, there requires an appointment process since there's otherwise no accountability. So to me, this was kind of a backdoor way to try to funnel some of those right-wing conspiracies, and Judge Canon didn't realize what the Department of Justice was just going to say, which is just, Your Honor, this is what the precedent is. There's no micromanagement. There's no day-to-day supervision or even month-to-month supervision. But Jack Smith has to comply like all special counsels do in all of these proceedings, whether it's a Republican-appointed one or one in a Democratic administration. They comply with the DOJ guidelines, and that's all we're going to tell you. We don't have to tell you anything more than that, and that kind of diffused it. I don't think that Judge Canon is going to dismiss on the basis of unlawful appointment or unlawful apportionment. That didn't seem to be where the hearing was going. But the fact that she was doing this show hearing and entertaining really a totally frivolous argument just shows you there's an undermining of the proceedings just by her holding that hearing. One of the other issues that's going to be discussed next week is special counsel Jack Smith's request to modify the conditions of Donald Trump's release, in essence imposing a gag order preventing Donald Trump from continuing to lie, where Donald Trump lies about, not lying in general, but lying that the FBI and DOJ are actively trying to hunt him down and assassinate him based on the general use of force policy that exists to anybody who is subject to a search warrant. Donald Trump says, look, it says use of lethal force. They're trying to kill me. They're coming after me. They want me dead. It's the same use of force policy that anybody, whether you're President Biden, whether your house is being searched, that's just the standard use of force policy that exists to every single search warrant. And special counsel Jack Smith put in a filing, and this to me was really a warning shot to Judge Canon, on this specific motion too. It's Judge Canon, look, Donald Trump, if somebody gets killed because of his behavior, he'll throw that person under the bus. He'll throw under the bus the murderer and say, oh, I had nothing to do with it, after riling the person up and bragging about how he riles up his violent supporters. But Judge Canon, neither you nor we have the luxury of behaving in that manner. We have an obligation to protect law enforcement, and that's what we are going to do. And under no situation are we going to be okay with our law enforcement getting killed because you're not going to make the right decision. Every court would impose a limited gag order relating to this specific type of conduct. Trump could go on, whine about Biden, whine about the special counsel, whine till his heart delights. Go for it. But you can't threaten law enforcement or try to get law enforcement killed. So that was filed on Friday night. There will be a hearing on that in the afternoon on Monday. And that's one of the grounds that special counsel Jack Smith will use if she rules the wrong way to get her removed. I think the chief judge of the Southern District of Florida is hoping Judge Canon makes the wrong decision so she can be removed. I think the 11th Circuit is hoping she makes the wrong decision. I think knowing Judge Canon, she'll probably just delay, at which point I think at some point Jack Smith's going to say, all right, if you're not going to rule, we're going to take a writ with the 11th Circuit, because just last week, another FBI agent had his life threatened. And in the motion that Jack Smith filed, he went in very specific detail about the type of threats that the FBI gets. Oh, if Trump takes over, you're going to be destroyed. And if Trump doesn't win, I'm going to hunt you down. Because when you tell Trump's violent supporters that the FBI and DOJ are trying to kill Trump, which is false. They're going to do violent things on Trump's behalf. Also, if you go look at some of the other hot takes that I do, I show you the types of emails that Donald Trump sends to his supporters. They're filled with violent rhetoric. We need to show force. Join me in this battle. We have to attack them. And he tries to be like, attack them with the force of our energy. But then in bold, it'll be like, we need to attack them. The battle begins right now. They've declared war. Join my war council. It's time we get after them. And he knows what he's doing right there. And he's doing that very, very intentionally. So that's everything, Judge Eileen Cannon. Michael Popok, ready to talk about the United States Supreme Court rulings. A lot to talk about, both in terms of what they ruled on and what they didn't rule on. I guess let's just start with what they did rule on. An 8-1 decision, United States versus Rahimi. The U.S. Supreme Court allows for there to be federal gun restrictions for domestic violence suspects, and it was an 8-1 decision. So in theory, you can go, wow, the eight Supreme Court justices agreed on something. But I think there's a little more than meets the eye here, because remember, the prior week, the Supreme Court had ruled not based on Second Amendment jurisprudence, but based on trying to destroy the ability of agencies to implement common sense regulations, that bump stocks do not constitute machine guns, and allowed bump stocks to be freely sold. So that was the decision 2 weeks ago. So then, Popok, as you said, they will issue a decision like that they know will rile up the American public, rightfully so, and piss everybody off. And then they take a case like this where it's like, it's really even a question that people are saying those who are under domestic violence restraining orders should have access to guns. And they'll be like, no, you can't have guns. We agree with that at least. And then they want to take credit for the most basic and obvious of things. Surely domestic abusers shouldn't have guns. Although the dissent, Justice Clarence Thomas, said, hey, everybody, remember that decision? The New York Rifle Association versus Bruin in 2022, that all of you right-wing justices agreed with me. If we really meant what we said in Bruin, and we're going to apply a historical tradition test, then if we go back in history, women were always abused by their husbands all the time. And there was no issues about domestic abuse in the 1700s. So therefore, how could we even acknowledge that this is what Justice Clarence Thomas is arguing, right, Popok? It's horrific. How could we even argue that domestic abuse is even a crime for purposes of Second Amendment jurisprudence? Domestic abusers could have guns if they wanted to back in the 1700s. Surely they could have guns now. And that's what we ruled in Bruin, everybody. That's the precedent right now. And the other 8 justices were like, nah, we're not going that far, Justice Thomas, but we'll apply your historical tradition test in Bruin however we want in future cases. Just on this one, we're not going to go that far as it relates to domestic abuse. Popok, what'd you think about that ruling, huh?
Wow. Yeah. And look, so this is what the ruling reflects. And the harbinger for the ruling, what I call the canary in the coal mine, is that a week before, obviously knowing that there was these opinions circulating, like the Clarence Thomas out on an island of his own, where he's left defending Rahimi, who in the main decision written and penned by Chief Justice Roberts, he spent a considerable amount of time and spilt a considerable amount of ink giving how depraved Rahimi was in abusing his girlfriend, physically abusing his girlfriend, and going on a shooting spree while he was the subject of a federal injunction against him having a domestic violence, and against him having a weapon. And what I said, and so you've got this mismatch of Clarence Thomas, the lone justice, who's defending the right of a guy parking lot. This is from the decision, who then went on who attacked her in her home despite the injunction, the restraining order, who then went on a shooting spree where everywhere he went, a fast food restaurant, a road rage incident, he pulled out his gun like he was in some sort of weird Wild Wild West moment and started shooting it off into the air or at people. And so when you see and this is like the secret decoder ring for the Supreme Court. When you see a description of the actual facts in a case, as opposed to what the MAGA Supreme Court usually does, which is says, let's not get bogged down with the facts. When you hear we don't want to get bogged down with the facts, that means they're about to make, in a judicial activist moment, new law, which they're not supposed to do without reference to the record below. When you hear them, on the other hand, recite the facts, that's because they're having trouble with somebody on the court like Clarence Thomas, and they want to, as they're circulating their drafts, they want to say, really? You're going to defend this guy? The guy who's the drug dealer, gun shooting, gun spree, woman abuser? That's who you're defending? And so when you see that, I was not surprised to see John Roberts speak at length about the actual facts in the case, because they don't really matter to what they're about to decide. It was done for a reason. And the harbinger, as I started to say, of this decision is Amy Coney Barrett in an unrelated decision 2 weeks ago that you and I talked about, and I did a hot take about, which is the copyright decision about whether a lawyer, a person, could get the copyright on Trump is small after his debate with Marco Rubio back in 2016. And could he actually register that with the Copyright Office? And Clarence Thomas and the others once again said, we go to a history and tradition test. We go back and try to find an exact identical duplicate law that was on the books during the First Amendment to this period to decide whether we're going to allow this or not. And even Amy Coney Barrett called that out and said, enough with the history and tradition test. It has its limits. First of all, why are we, to paraphrase Justice Roberts in the most recent decision, why are we trapping the law in amber? Why are we making it where we have to go find an exact identical historical twin in order for us to provide the lower courts with a test? We're supposed to give them a test. We're the Supreme Court. This is Amy Coney Barrett. How are they supposed to do their job? And what are you going to do when you hit the point when there is no history or tradition around a certain regulation? How do we regulate nuclear power plants? What would the founding fathers have done? Well, they didn't have nuclear power. I mean, that's where you're at. She said, just do a judge-made test. So that's what we're supposed to do, not history and tradition. So when you see on the special decoder ring edition of Legal AF, when you hear the words history and tradition by Gorsuch, by Kavanaugh, by Alito, by Thomas, now what they want to do is remove the regulation and the restriction, and they're going to do it by referencing the vast historical tradition of our country. Even John Roberts and the other 7 on the Supreme Court said that Clarence Thomas, as a Second Amendment absolutist, is off the chain, is an outlier. We can't even go that far. And what they did is, and I took him to task on a hot take on this, John Roberts elided over. He conflated in order to act like it wasn't us that was at fault with our Bruin decision 2 years ago, even though Clarence Thomas wrote it. It was the way the trial courts are interpreting it. Now, Ketanji Brown Jackson, in her concurrence, said, no, it's our fault. We didn't give them the proper guidance. We said, go and find an historical twin. If you can't find an identical law about gun control in 1791 or the 1800s, despite the fact that contextually, looking for a law unmoored from the historical context of how women were treated in the 1790s and 1800s, or even now, how Black Americans, now Americans, were treated, is unhinged, to put it mildly. A woman, let's just take domestic violence and the Rahimi case. There was no crimes against domestic violence during that old-timey period because women were considered owned as chattel by their husbands. They didn't have the right to vote. Some people noted it in the back. In honor of my upcoming daughter, I found this amazing thing from the suffrage movement. Women bring all voters into the world. Let women vote. We had to have signs and posters like this in this country because the women didn't have the right to vote. So you can't go, well, you could have freely abused your wife back then, so you're allowed to have a gun now. That is where Clarence Thomas has gone. It's not a slippery slope. It's where he's gone. And so Chief Justice Roberts said, well, we need to sort of walk this back a bit. You don't have to look for an exact twin in the law. You just have to find a law that is part of our history and tradition that undergirds the law. And since there's a history and tradition about taking guns away from bad people who will harm people in public, we'll find that this law about domestic violence should disarm people like Rahimi temporarily. I don't want to oversell Rahimi. It is clear that under Rahimi, that when Rahimi rehabilitates himself and is no longer a threat to society as adjudged by a judge, he's going to get his weapons back under the Second Amendment. As I said recently, the amendments that came from the original Constitution after the framers of the Constitution said, now that we got the living, breathing document of the Constitution done, we better go back and make some changes and make some additions. First 10 amendments, the Bill of Rights. They are not ordinal. They are not ranked. It is not like the First Amendment is above the Second Amendment, nor is the Second Amendment above all other amendments, including the First Amendment. They are 10 amendments. But the way that the Supreme Court in Maga has supercharged and turbocharged the Second Amendment and made it so robust, it knocks over all the other amendments. You know, they're so focused and fixated on the right to bear arms, now an individual personal right outside the home after the Bruin decision. Now they see what it wrought at the trial level, right? Now they see the trial judges struggling. They're making trial judges historians to have to go back with their law clerks to go back and do a search as opposed to just giving them a standard test. So that's why it looked like 8-1, but you had about 5 concurrences that were written, 1 dissent that was written, and everybody joining in on the majority opinion except for Clarence Thomas and the left wing, or the sensible wing of the Supreme Court, Sotomayor, led by Sotomayor, applauding at least the rollback of Clarence Thomas' ridiculous absolutist Second Amendment position that put him in a position, Ben, to defend a violent domestic abuser who went on a crime spree and is a drug dealer.
Well, you know how we always say everything with this MAGA Republican Party is projection or confession. It's really the same with the Federalist Society movement. They went around for decades calling the liberal judges activists and that they're coming up with law as it goes, when in fact the so-called liberal judges were actually applying the law and applying the precedent, and also in a common sense way recognizing the issues that exist in the current modern world that we inhabit today. But what the Federalist Society did is they would create these labels to make it seem like they were smart and that they were intellectuals, but in fact, they're really sociopaths who just try to come up with a framework. So it's heads, I win, tails, you lose, no matter what the outcome is, right? So they're states' rights until they want and are okay with a federal abortion ban. They are strict textualist or strict constructionist until you read what the Second Amendment actually says. And it says a well-regulated militia. It uses the word regulation and it talks about a militia. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So then they go, oh, I guess we can't actually be strict textualists there, because if we read the text, it's the only amendment that actually uses the word regulation. And our whole point is that there shouldn't be regulation. So, let's come up with another test and call it the history and traditions test. And whose history and traditions? The same people who say, make America great again. Whatever that means to you, we're going to find our own version of history that suits us. And we're going to come up with an outcome based on how we read history, not even what really happened in history. Because if you go back to, there weren't AR-15s. I mean, there weren't guns and machine guns or anything close to what guns look like today. So if you were really going to do a history and traditions test, anything but like muskets, right, or whatever should be all banned to begin with. But no, we're going to do our history and tradition test, and we're going to apply that. But that, to me, was one of the biggest revelations, because when I'm in law school, when you're in law school, they teach you doctrines about being a strict textualist and a strict constructionist and states' rights and the words conservatism and precedent and super precedent. But then you learn, as you evolve from law student to law practitioner, to kind of this observer of the hustle. And you go, wait a minute, y'all just made all of this stuff up in order to justify the outcomes that you wanted. You're not textualists. You're not even true history and tradition. You're not states' rights. You're not even conservative unless you want to conserve the monarchy. And I think we see that on full display here. You certainly don't want to conserve our democracy. And how do we know what you don't want to conserve our democracy? Because you haven't even ruled on the absolute immunity decision. You haven't ruled on it. You have not ruled on a critical decision. So no matter what they rule, they've already granted a form of de facto immunity to Donald Trump from being held accountable for leading an insurrection against our country by not taking the case on an expedited basis when Jack Smith requested it in December. Then when Donald Trump requested a stay later in February, they convert that into certiorari and then accept it for oral arguments and then delay the thing where here we are, June 22nd, and there's no ruling. They've already given him a de facto immunity. They've already given him the power that no one has in this country. They've given him the power of kings because they've blocked a trial arbitrarily, capriciously, recklessly, maliciously. We'll talk about that and more. Let's take our last quick break of this. Wait, before we do it, patreon.com/legalaf. Patreon.com/legalaf. I want to plug that before the quick ad break, just to remind everybody that we had a Zoom meeting already with partners and associates of our Patreon. We love posting the lectures. I did a full Supreme Court lecture that everybody can
Part one.
go and take a look at.
Part one.
That's just part one. Yeah, part two. Part two. I got to get to work on that. But anyway, it helps grow the show. We're not funded by outside investors, so that's a major way that you can all help out. Patreon.com/legalaf. Let's take our last break of the show.
Proper sleep can increase focus, boost energy, and improve your mood. Introducing Beam's Dream Powder, a science-backed healthy hot cocoa for sleep. If you know me, you know that Dream has been a game changer for my sleep, and boy, do I need sleep these days. I drink Beam's Dream Powder each night in order to get my optimal sleep. And I gotta say, I wouldn't be recommending this if it didn't actually help me. And today, my listeners get a special discount on Beam's Dream Powder. Their science-backed healthy hot cocoa for sleep with no added sugar. Better sleep has never tasted better. Now available in delicious flavors like chocolate peanut butter, cinnamon cocoa, and sea salt caramel, with only 15 calories and 0 grams of sugar. Other sleep aids can cause next-day grogginess, but Dream contains a powerful all-natural blend of reishi, magnesium, L-theanine, melatonin, and nano CBD to help you fall asleep, stay asleep, and wake up refreshed. The numbers don't lie. In a clinical study, 93% of participants reported Dream helped them get better sleep. Beam Dream is easy to add to your nighttime routine. Just mix Dream into hot water or milk, froth, and enjoy before bed. Find out why Forbes and the New York Times are all talking about Beam and why it's trusted by the world's top athletes and business professionals. If you want to try Beam's best-selling Dream Powder, get up to 40% off for a limited time when you go to shopbeam.com/legalaf and use code legalaf at checkout. That's shopbeam.com/legalaf and use code legalaf for up to 40% off. I've been taking Timeline's MitoPure for over a month now, and I feel absolutely incredible. I have way more muscle strength and energy to get things done. And as you may know, there's been a lot of legal and political news lately, and Timeline's MitoPure has helped provide me with the energy to get through these long days. Timeline, a Swiss-based life science company, is a global leader in urolithin A research. They spent 10 years doing research to bring this product to market. Urolithin A is a powerful postbiotic that is nearly impossible to get from your diet alone. MitoPure is the first product to offer a precise dose of urolithin A to upgrade your mitochondrial function. Take 2 soft gels a day for 2 months, and you can see significant improvements in your cellular energy, muscle strength, and endurance. After 4 months of taking MitoPure, you'll feel yourself getting stronger, recovering faster after a workout, and experiencing less inflammation, all part of your healthier aging routine. MitoPure is the #1 doctor-recommended urolithin A supplement that is NSF and Clean Label Project certified. Timeline has MitoPure in 2 product designs to fit your needs. Their berry powder, which is great to mix into your breakfast yogurt or daily smoothie, and their soft gels for those days where you're on the run and want a convenient grab-and-go option. Timeline is offering 10% off your first order of MitoPure. Go to timeline.com/legalaf and use code LegalAF to get 10% off your order. That's timeline.com/legalAF.
Welcome back. Great ad reads, Michael Popak. Michael, share with us, if you can, not just, we talked about what the Supreme Court ruled on, the fact that they have not ruled on the absolute immunity decision, the fact that they have not ruled on the obstruction of official proceeding, that they are waiting so late in the term. Tell us about the import of that.
Yeah, I'm going to do that. I want to make one comment for our legal AFers. This whole originalist textualist thing that you talked about is really, as you said, a sham. Even the United States Supreme Court, its role in our society, its function and its interpretive function of finding, at least for constitutional law, whether there is a constitutional violation or not, is not found in the literal text of the U.S. Constitution. It's nowhere. We can spend time, we can throw up the Constitution that talks about the Supreme Court, and it's nowhere to be found. Why? Because it's an interpretive result of John Marshall, the Chief Justice in the 1800s, in a case called Marbury versus Madison. If it wasn't for Marbury versus Madison and John Marshall, and if you go to the Supreme Court, like I did with my wife a couple months ago, there's a huge statue, 2 of them, but one giant one of John Marshall, for good reason. There would not be a United States Supreme Court, but that's all from interpretation, not from the original text. It's irony that, of course, is always lost on MAGA. In terms of the timing issue, Judge Chutkan, always, sometimes when I go to a movie and they do all the previews, I forget what movie I'm about to watch. And we forget about Judge Chutkan. She has been patiently waiting with a pin in her case for all this time. When I said it's 114 days, 115 days since oral argument, it's even further back, almost 3 months further back from when she put a pin in the case while the immunity issue is being fully litigated at the D.C. Court of Appeals level, 3-judge panel. Then, and just to remind everybody, the special counsel tried to short circuit and go right to the United States Supreme Court and demand an immediate appeal issue so that they would make the decision in the first instance back in November and December, not the DC Circuit Court of Appeals. They said, no, we want a record. We like when records go fully up on appeal from the lower court. Let's go jump through all those hoops. So that takes a minute. And then you and I sat around tapping our foot, waiting for a month to go by, which we thought was sort of long. But, in retrospect, we shouldn't have faulted the D.C. Circuit Court for making their ruling. And of course, there was no immunity for crimes like this, personal crimes that benefited Donald Trump to try to cling to power. And then every time that Supreme Court had an opportunity, led by MAGA, to benefit Donald Trump, they did. Let's do oral argument, but let's do it on the very last day of the calendar, literally the last oral argument we're going to hear. All right? That was end of April. And now, should we issue the order, the decision at the beginning when we start issuing orders and decisions, or should we wait until the last day in July, apparently, or maybe next week, although I doubt it, right before we go up on our plate? Let's do it then. We'll do it the last day. And why this impacts, of course, Judge Chutkan, is she has already said that whenever I get the case back, and I want to talk about what kind of case she gets back, assuming she can just go right back to trial on the indictment, and I'm not sure that's a foregone conclusion, she has said, I'm going to add 89 days. I'm going to add 90 days for prep, because that's where we were when the case was put on ice back when the immunity appeal was taken. So plus 9, let's just do plus 90. Let's say she gets the case middle of July. She calls everybody in. She says, we're going back to trial. This is the direction I've been given by the mandate of the Supreme Court, and this is how I'm going to do it, assuming it's that easy. Then if you add 3 months, middle of July, August, September, October, talk about an October surprise. The October surprise is going to be, how can she possibly get this case up and running a month before the people, 3 weeks before the people vote? Not happening. And that is what, as you said, they gave Donald Trump immunity, and an immunity and holding America hostage so that the American electorate doesn't have what they need to make a fair decision about whether they're voting for a former president who's a one-time felon or a two-time felon for two different things, including presidential election interference, which is important to our democracy, but not to this United States Supreme Court. So they're waiting till the very end. And I'm not even sure that at the very end, it's a decision. They could, I know this is going to freak people out, they could ask for re-argument. The Supreme Court could say, you know what, there's an issue that wasn't really fully briefed. Let's have some mini rebriefing and a new argument that we'll hold maybe over the summer. I mean, they've held arguments over the summer before. The special counsel, special prosecutor Leon Jaworski thing happened in July after the term had ended. So they can get all back together again when it's important. So they could, and what does that do? Another day, another delay, another disconnect with justice. And so that's what we're watching. And then what they've done is, as we said earlier, is they sort of staged and sequenced how they're dribbing and drabbing and spoon feeding us their decisions. Let's front load all the ones where it looks like we're getting along. 6-3, 7-2, a couple in there that are, well, the 6-3s aren't. The 7-2s and the 8-1s and the 9-0s, those are the ones they're front loading with a couple smattered in there. And we'll give them abortion, medicated abortion, and we'll take away domestic violence abusers' gun rights and things that people can try to rebuild the integrity and the integrity and the respect for the Supreme Court until they drop simultaneously, probably, the decision about whether all the Jan 6 insurrectionists, including Donald Trump, can be tried for and indicted for obstruction of an official proceeding. Donald Trump having a special extra that probably keeps those claims in front of him because of the fake elector certificates, and this decision about immunity. And then lastly, even if there's no re-argument, they actually issue a decision, which is the next wave is going to come on June 28th. And to answer the question in the chat, who sets the time and how they run their cases, their dockets, their calendars, and their opinion dropping? The Supreme Court and the majority of the Supreme Court. There's no rule, there's no regulation, there's no Judiciary Act of 1787. Nothing controls them. And if they want to do re-argument, they're going to do re-argument if they have the votes. So if they issue their order and they send it back to Judge Chutkan, I'll leave it on this. And the direction to Judge Chutkan is use our decision and figure out which of the indictment issues fall into the personal benefit category and which is official conduct category, and do that in an evidentiary hearing. Add another 30, 50, 60 days onto this, and we're well beyond it. And if Donald Trump, if the people of this country want to restore not just a president who commits criminal acts while he's in office, but a criminal president back into office, he's going to dismiss all the federal. He's going to order his new Department of Justice to dismiss all the cases against him. He's going to give immunity to wherever he can, and he'll deal with the state court proceedings as needed. So we have to see what the directions are even back to Judge Chutkan. If she has to hold another hearing, another briefing, it's done. It's over. It's basically over now. If she can do something else, if she on her own can just say, I'm going to take a razor here and I'm going to split the indictment in this way, or I'm going to with the jury instructions, let the jury handle it. It depends on what the opinion is going to say that you and I are frothing at the mouth in order to read and bring to our audience. And that one, Ben, if there's going to be a reading of dissents, and there will be, depending upon what decision will be, we should try to get a live stream on that, and you and I and the other contributors get on there and talk about it.
Well, let me just show you what the Supreme Court could have done and should have done, because the highest court in New York, which is basically the state court equivalent of a Supreme Court. New York's a little confusing. Their trial court is called the Supreme Court. Their highest court, which in other states would be called the Supreme Court. New York loves to just be a little tricky with law students and practitioners. They call it the Court of Appeals. So New York's highest court, though, when Donald Trump rushed to them with a request about the gag order that was imposed in the Manhattan criminal case, here is what they wrote. They said there's no substantial constitutional questions at all. And sua sponte, on their own initiative, they just rejected it. They dismissed the appeal without even briefing, because they're like, what is this? Like, what are you talking about? And that's how the United States Supreme Court should have dealt with Donald Trump's claim that you can order SEAL Team 6 to kill your political opponent. Pull that up one more time. Imagine if the United States Supreme Court, not the highest court in New York, when Donald Trump said, I can have SEAL Team 6 kill my political opponents. Wouldn't a rational United States Supreme Court say something like this? Appeal dismissed by the court, sua sponte, upon the grounds that no substantial constitutional question is directly involved. That's all the United States Supreme Court would have had to do, and then Donald Trump's case would have gone to trial. Months ago, we would have had that trial, and just like in New York, he would have been convicted, because a jury of his peers, when evidence is presented in our judicial system, an adversarial system, a jury would see it and they would go, wow, that's someone who's very, very guilty. But the United States Supreme Court's like, so maybe, just maybe, a president could order SEAL Team 6 to kill a political opponent if it is an official act. But if it is unofficial, perhaps the district court judge needs to make very specific rulings on a one-by-one basis about each specific act. There's some interesting questions. There is no. You want to talk about a history and tradition test, Clarence Thomas? You want to talk about a history and tradition test? How about the history and tradition of the United States of America was a rejection of the monarchy? There was a doctrine of absolute immunity. It was called kings. It was called monarchs, authoritarians, people who are literally above the law and can do whatever they want. Our system, we the people, created a system where it's we the people. Our system is a rejection of that. It is the most basic historical tradition analysis that you could ever give, that there should not be absolute immunity. Just me even saying the idea that a president can order SEAL Team 6 or the military to kill political opponents? What are you saying? President Joe Biden could order the Secret Service to go and just kill political enemies and then go absolute immunity? Can't do anything about it. That is being entertained as something that can be done because Donald Trump is asking for it? Like, what are you talking about? This is the United States Supreme Court that said that President Biden did not have the discretion to forgive student loan debt the way he wanted to. So you don't have the discretion to forgive student loan debt. You do have the discretion to murder whoever you want to murder under the doctrine of absolute immunity. What in the world are you talking about? And that, though, is why, Michael Popak, I think this show is so important, because we have to make these concepts accessible, understandable. We have to unpackage the way these right-wing Supreme Court justices, the Federalist Society, try to make this inaccessible to the public so that they can overcomplicate these issues. These are not complicated issues. These are fairly basic constitutional questions that are being overcomplicated in order to try to undermine our Constitution and our democracy. And I'll conclude with this. What the Manhattan District Attorney's Office also said in one of their filings is that, look, keep this gag order in place on Donald Trump. He's a threat. He's out there threatening people. He's threatening. He'll continue to. He'll threaten jurors. He'll threaten the family members of this staff. Look, the witnesses are no longer testifying. So, Judge Merchan, if you want to remove the gag order as it relates to trial witnesses, since they don't have to testify, I get that, but he can't be threatening jurors. He can't be threatening family members. That's not the United States of America. Like, what in the world are we talking about here? So that's what the district attorney's office said. And one of the things they pointed out, too, is they're like, okay, so in Trump's motion, they are whining that the briefing schedule, which has briefing done through even past when the debate's going to be taking place, that's unfair. And the district attorney's office is like, just stop whining. If you didn't like the briefing schedule, then go to the judge and ask for an expedited briefing schedule. You didn't ask for an expedited briefing schedule, but now you whine about the briefing schedule so you can complain and say, oh, this is so unfair. But you had the opportunity to make the request to expedite it. You didn't because you want to whine. And that piece of it, when they want to tear down and make a mockery of our judicial system, that's the part where I'm good with an adversarial system. You've heard me say before, I'm fine with criminal defense lawyers representing the worst of the worst people accused of horrible things. That's part of our system, even criminal defense lawyers who want to represent Donald Trump. But the moment you try to undermine the very system to create something where people can have SEAL Team 6 kill opponents, not good with that. I'll give you the final word on the show.
Yeah, no, listen, you've got Donald Trump and his lawyers who just use a fire hose to try to pressure test our entire, all the things that gird and are the guardrails around our criminal justice system, just as he tried to do with the system around our election process. We didn't talk about it today. We'll pick it up during the midweek. But, Donald Trump just filed a motion to disqualify Judge Engoron, the judge who sat through 12 weeks of trial as the trier of fact and a bench trial to determine that Donald Trump committed fraud along with everybody related to him and his organization for the last 10 years, persistent fraud, as that term is used in New York, to try to undermine the $465 million civil fraud judgment that is ultimately up on appeal because some person not related to the case went up and tried to kibitz with the judge after a hearing, a lawyer in New York, and who's not a party to the case, who's not a participant in the case, who's not a lawyer or party to the case, just a guy who went up to and did a drive-by, whether on purpose to try to get Judge Engoron disqualified or otherwise. And Judge Engoron sat and listened to him for a few minutes and then went on and wrote his decision about not incorporating anything that he learned from this guy, this sort of crackpot. And they said, aha, back in May, as reported in May, there was a meeting between Judge Engoron and this other person, and that was ex parte, which shows a purposeful lack of understanding of what the term ex parte communication means in our legal system. That's when a party or the party's counsel has a conversation outside the presence of the other party or counsel with the judge. The judge has to both stop it from happening, and if he can't, he has to disclose it immediately that happened, and then determine whether he can continue the case or otherwise. That's not what happened here. This is a stranger to the case. But all they want to do, just as they try to do with Fani Willis in Georgia, is try to disqualify prosecutors, disqualify judges, so that Donald Trump won't be held accountable for his own actions. We'll talk about that another day. But here, the Manhattan DA is right on, and Merchan is going to have to make a decision. I thought before the debate, but based on what you've just said on the timing of the briefing schedule, which was adopted basically and conceded by Trump's lawyers who don't know what they're doing in the courtroom. The only lawyer in state court, criminal court for Donald Trump that knows what they're doing is Susan Necklace, and she has receded into the woodwork and doesn't want to really be associated with the case any longer. So she's leaving it to Beauvais and Blanche, who are not state prosecutors. Our colleague Karen Freeman-McNiffalo rightly talks about this food chain in our law practice, where state court practitioners and federal practitioners don't see eye to eye. They don't really practice. They're divided by two different court systems. And what we're watching is they don't know what they're doing. Just like Alina Habba, who's a dabbler in New York practice. She's really a New Jersey parking garage lawyer. Look it up. So they screw it up all the time. Procedurally, they just don't know their way around the procedural law, the criminal procedural law in New York, or what you're supposed to do. So if Merchan is going to keep that gag order in place up and through the time until there's an appeal, because Donald Trump is a criminal, now convicted felon within the criminal justice system for New York, and still has to be regulated and administered by the judge and only the judge. And so he's not going to say, well, it's over now and you can do whatever you want. And you can say whatever you want. No, if anything, the upcoming debate and the impact, as Alvin Bragg's office has said, Alvin Bragg's gotten 56, and the number's probably higher now, over 100, I'm sure, death threats to himself and to people in his office. Death threats. So has the judge, so has the judge's daughter, so has the principal law clerk for Judge Engoron, so has Judge Engoron, so has Fani Willis, so has Letitia James and everybody in her office, because of Donald Trump, not because of people who don't pick. He, as we know, in his call and response, stochastic terrorism, and he know, like you said, he knows what he's doing, is causing this fomenting of discontent and causing violent rhetoric to be used. We had a guy set himself on fire in the back of the courthouse during the Trump trial, right? We've had judges and their families attacked. We had Nancy Pelosi's husband, and it should have been Nancy, according to the criminal defendant, hit with a hammer over his head. Okay, this happens every day. Donald Trump doesn't care. He doesn't care. He'll do anything to get elected, or as our President Biden has said now, and I think rightly so, something is broken in Donald Trump since he lost legitimately the 2020 election, and we're seeing the ramifications of it now.
Well said, Michael Popak. And that's why it's important that we not just discuss this here with everybody, but we then share as a community this information with others and make this accessible to others, this information, this data. Knowledge is power, and that's so the case when it comes to this legal stuff that is being utilized the way it is, in a way that is trying to manipulate what I think are fairly basic concepts when we break it down. Michael Popak, the next time we see you, you will be Michael the Papa Popak. So we wish you all the best. We are so excited to see the photos as a community, and we wish you, we wish Natasha, we wish everybody the best. You've got the easy job, Popak. It's Natasha that
oh, I know.
I know and our love, in all seriousness, our love goes out to her, to you, to your entire family. We so appreciate everything you bring to the Legal AF community, and we're so looking forward to the joy your baby girl is going to bring you and your wife and your growing family. Legal AFers, thank you so much. Make sure you check out Patreon, patreon.com/legalaf. We don't have outside investors, so one of the ways we grow this community is through our Patreon. Listen to the Popak lectures, the lectures that I do. Join our quarterly partner and associate meetings like the one we just had. We have that one recorded that we just did, where we answered a lot of questions as well. So if you weren't able to attend the last one, you can watch it on the recording. Patreon.com/Legal AF. And of course, we'll keep on giving you updates, breaking news as it develops. Thanks everybody for watching Legal AF. I'm Ben Meiselas, joined by Michael Popak. Have a wonderful day.